What I would like to do is stress that, yes, security management initiative. I'm not just dealing with security in terms of flak jackets, high walls, barbed wire, and secure cars. What this is all about, the business we're in, why donors finance, why my mother gives money over the telephone, why I engage, why organizations exist, it's about helping people, it's programming, it's in the field. To do that, you need access. But there's no point in having access if it's not safe and secure. So safety and security is not a standalone, it's an enabler to get access and help these people. So the key point here is access. And to be on the ground in a safe and secure way, in a sustainable manner, requires a number of things you have to do, which we all know are not always met in the field. There are a lot of kooky things happening there. And I think the document would probably help towards structuring this in a little bit of a different manner than we've done before, and reorganize the different elements of good practice in a slightly different manner and posing different questions with respect to that, which I think is very helpful in articulating how these things fit together, how governance and field and HR and finance fit together.
The paper contains a condensed summary of the law, civil and criminal laws in those countries surveyed, including some case studies to try and make the paper less abstract as possible and focus the minds on case studies that may be relevant in the aid agency organisation context. We also reviewed the legal principles that determine the issue of which national law applies and which national court can hear the dispute. That is an immensely thorny issue, and I'm not going to talk about it any further, but you can read the paper, which we've tried to use some sort of abstract examples to focus the mind and then tease out the very basic legal principles on that. Clearly that's a very important issue for aid organisations because they work within an international context. We then sought to formulate some global principles surrounding the legal responsibility of employers across those countries surveyed, and the standards expected of them before then formulating what conclusions and recommendations we can draw for aid organisations. What were the challenges with this project? And when I first picked up the brief, I perhaps thought that these challenges were insurmountable. There were a number of obvious challenges, and they were as follows. Firstly, forming valid generalisations about the duty of care across 5 different legal systems, with each having their own obvious linguistic, terminological, and sometimes conceptual differences. And even within the United States, which is technically one jurisdiction, there are in fact 50 states which each have their own idiosyncratic rules and principles. However, we were, I think, able to do this, at least to some extent, and there were a surprising number of common principles and approaches. The second challenge was converting an immensely legally complex and often abstract subject into simple, comprehensive language that non-lawyers can understand, without, however, oversimplifying the subject or giving a misleading picture of what the law actually is. And there were 2 specific problems here. The first is the fact-sensitive nature of the duty of care concept, which can make it very difficult to generalise in the abstract about what it actually means and how it's to be applied, and how it's to be applied to every aid agency or every sphere of activity. And unfortunately, for those of you out there that want firm answers, there are no black or white answers, and everything really is grey. The second specific challenge was the international environment in which many aid agencies operate, and that, as I said earlier, can and does very much so give rise to very difficult legal issues concerning the conflicts of applicable national laws, or which country should determine the dispute between the aid organisation and the staff member. Because you might have, say, 3 or 4 competing different jurisdictions that could try the case, or the same number of laws that could be applicable to the dispute. Finally, applying the duty of care in practice in a relevant and meaningful way for international aid organisations, and we sought to do this by finding case studies in many of the countries surveyed to try and tie the abstract principles into concrete facts to show how courts apply the law to the facts, and what, through comments, aid organisations can draw from those reported court decisions.